what exactly is the meaning of the word bail. I hope you have heard of the term bailment. Everybody, yes or no? You must have heard of the term bailment. Now, when you look at bailment, what generally happens? A, let us say, gives the goods to B, and at the same time, A retains the right to take back. A gives the goods to B, and A generally retains the right to take back the goods because the goods belong to him. So he can take them back. That is bailment. You see, the word bail has also been derived from bailment. And what exactly does it mean? Here, the court releases, or let us say, gives the arrestee to the surety or his own self. To the surety or his own self. And in a similar fashion, the court can take back that particular arrestee or accused. So, if you see the process of bail and bailment, they are quite similar to each other. Bailment talks about the goods can be taken back by the bailer at any particular point of time. And the word bail has also been derived from bailment, where the court gives that particular accused, the arrestee, in the custody of the surety or his own self, and then the court has the right to take back that particular accused when the bail is cancelled or when the accused is convicted and sentenced to imprisonment. So then in section 485 of BNSS, the bail bond is cancelled, the bail bond is executed. What I am trying to say here is that the court has a right to take back that particular surety in its custody, take back the particular accused in its custody from the surety. Like here, A can take back the goods from B, the court can take back the arrestee from the surety or his own self. That is how you can draw an analogy between bail and bailment. And bail, in fact, is derived from the word bailment, because the procedure and the rights are somewhat quite similar when we talk about bailment and bail. You see, I have earlier also mentioned this once, that bail actually is a form of custody. It is not that you are acquitted and you are free. Otherwise, a person on bail and a person acquitted, there will be no difference. You understand? If I say that this person has been released on bail, and if I say this person has been acquitted, do you see that there is in commonsensical language also, you will see that there is a lot of difference in a person released after acquittal and a person released after granting of bail. Bail granted, the proceedings are pending against you and you are not completely free, there will be restrictions upon you. But when we talk about the release of a particular person after acquittal, that entails that the person has been completely released from any kind of liability. So when we talk about bail, bail is not that you are now completely free at your own liberty. Yes, you are not confined. Yes, you are not being jailed. Yes, you are not being kept in custody. Yes, you are not in the custody of the police or the court, but still you are not completely free. What the court does is, there was a particular case, there were a lot of cases here also it was mentioned. The case was Phulchand Shah versus the Union of India, 2000 Supreme Court. Here if you see, the court had said that bail is a form of custody and bail is nothing but custody of the surety or your own self. What is happening is, where the bail is being granted by the court, where the bail is being granted by the court, they are actually transferring the custody to the surety or they are transferring the custody to the accused himself. आप सोचो जमानती की श्योरिटी की जरूरत क्यों पड़ती है? श्योरिटी जाकर किस चीज की अश्योरेंस दे रहा है कोर्ट में बेल के टाइम पे? वो ये कह रहा है कि हाँ भाई ये व्यक्ति भागेगा नहीं, ये इस व्यक्ति को जब भी बुलाओगे ये आपके पास आएगा, ये सारी प्रोसीडिंग्स अटेंड करेगा, ये एविडेंस के साथ टैंपर नहीं करेगा, ये विटनेसेस को थ्रेटन या इंटिमिडेट नहीं करेगा. इट इज वेरी क्लियर दैट इज द इंटायर रोल ऑफ द श्योरिटी, जमानती. और श्योरिटी समटाइम्स गिव्स सिक्योरिटी एज वेल. सिक्योरिटी का अगर आप लोग मतलब समझते हो, सिक्योरिटी इज एन अमाउंट, और इट इज टाइटल डीड्स टू योर प्रॉपर्टी, और इट इज लेट अस से आपकी मोटरसाइकिल के पेपर, और इट इज एन एफडी विच इज देयर इन द पर्टिकुलर बैंक. श्योरिटी जो जमानती होता है वो सिक्योरिटी भी देता है कि हाँ भाई मैं आपको ये बात अश्योर कर रहा हूं कि दैट दिस पर्सन who is being released on bail will not run away. This person who is being released on bail will be present whenever you require, and this person who is being released on bail is not going to commit any further offense or tamper with evidence etc. I am giving you that assurance. तो ये assurance आप दे क्यों रहे हो? How can the court believe on somebody just on the basis of a 10,000 rupees FD or a 50,000 rupees motorcycle that the accused is not going to run away? भाग गया तो श्योरिटी भी अरेस्ट हो जाता है. श्योरिटी की जो सिक्योरिटी जमा है, एफडी, मोबाइल, ये मोटरसाइकिल के पेपर एक्सेट्रा, उसको भी जब्त कर लिया जाता है. दैट इज ऑल्सो फॉरफिटेड. विल डील विद इट लेटर. उसको भी फॉरफिट कर लिया जाता है, एंड द श्योरिटी इज ऑल्सो अरेस्टेड. क्यों? व्हाई? श्योरिटी हैज नॉट कमिटेड एनी ऑफेंस. Surety has not at all committed any offense, but we are arresting the surety because we had given the accused in the custody of the surety. वो accused को हमने खुला नहीं छोड़ दिया था कि जाओ जो मर्जी करना है करो. Yes, आपके पास कुछ लिबर्टी आ जाती है जो आपके पास लॉकअप में या जेल में नहीं थी, but still the accused is not completely free. accused को हम surety की कस्टडी में ट्रांसफर कर रहे हैं कि हमारे पास से अब हम ये accused तुम्हें सौंप रहे हैं, आप इस पर्टिकुलर अक्यूज्ड का ध्यान रखेंगे, ये अक्यूज्ड कहीं भागेगा नहीं, ये आपकी कस्टडी में है, ये अगर भागा तो तुम गए. यू आर गोइंग टू बी अरेस्टेड एंड योर सिक्योरिटी इज ऑल्सो गोइंग टू बी फॉरफिटेड. सो इट इज वेरी क्लियर दैट द अक्यूज्ड इवन आफ्टर ग्रांटिंग ऑफ बेल इज नॉट कंप्लीटली फ्री. रादर द कस्टडी चेंजेस एंड द कस्टडी इज ट्रांसफर्ड टू द श्योरिटी. वो कस्टडी श्योरिटी को ट्रांसफर कर दी जाती है. और कुछ अगर बहुत लेस सीरियस ऑफेंसेस जहां पर हमें नहीं लगता कि बहुत ज्यादा ग्रेव नेचर है, इस वजह से वो व्यक्ति अपना घर बार, दुकान, बिजनेस, नाते रिश्तेदारों को छोड़कर भाग जाएगा, ऐसे पर्टिकुलर केस में हम उस पर्टिकुलर अक्यूज्ड की कस्टडी उसको खुद ट्रांसफर कर सकते हैं कि भाई तुम अपना ध्यान रखो और हम तुम्हें पकड़ेंगे अगर तुम भागने की कोशिश करोगे तो. लेकिन यहां पर कोर्ट को जनरली पता होता है दैट द डिग्री ऑफ ऑफेंस इज सच that the accused will not run away. अब आप मुझे बताओ, आप पर एक छोटा सा लेटर से ट्रैफिक का चालान आ जाए, ऑफेंस तो वो भी है. मान लीजिए आप पे किसी को गाली देने का चालान, गाली देने का एक्यूजेशन आ जाए, या आपने किसी को धक्का दे दिया. अब आप इतनी सी बात के लिए अपनी फैमिली को, अपने बिजनेस को, अपनी एम्प्लॉयमेंट को, या जैसे आपके केस में अपनी पढ़ाई को छोड़ के भाग जाओगे? नहीं भागो. These are those offenses which are not very serious in nature. थोड़े दिन बाद हम petty offenses की कैटेगरी पर भी आएंगे, but these are those offenses which are not very serious in their nature. So when the offense is not very serious in nature, the court also knows that this particular person is not going to run away. This particular person is going to stay, and this person is not a flight risk. ये भागेगा नहीं. इसीलिए हम कभी कभार उस पर्टिकुलर श्योरिटी को हटाकर ये कहते हैं कि चलो तुम अपना खुद का पर्सनल बॉन्ड एग्जीक्यूट कर दो. सो टू थिंग्स यू शुड अंडरस्टैंड. नंबर वन, एन एनालॉजी कैन बी ड्रॉन बिटवीन बेलमेंट एंड बेल. लाइक द बेलर कैन टेक बैक द गुड्स फ्रॉम द बेली, in the same situation here the court can also take back the accused from the surety. Please be very clear about it. Second, bail does not mean that you are 100% free. Bail simply means that your custody is being transferred from the custody of the court to the custody of the surety. Are we clear with this?